If you've been served with an order of protection in the state of Tennessee, I'm going to go over how that works, how that process works, what you need to know, what are the possible consequences that you're facing here. If you live in Tennessee, I handle a lot of these in Memphis and Shelby County, so it's going to be primarily based in that. So if you live in this area and you've got an order of protection, you're going to have to go through this. Or maybe you live somewhere else. Maybe you live outside of Memphis or even outside of the state of Tennessee, because these things can go anywhere. Somebody here in Memphis could get a temporary order of protection against you wherever you live in the United States and serve it on you. Have local law enforcement, sheriff deputies where you live would come to your house, give you the papers. You're now served, and you have to answer to this. You have to, if you want to fight it and don't have it go on your name, then you're going to have to come here and go to court and get a lawyer and go through all that. So that's how the service part works. So even if you're outside of the state of Tennessee, you can be served with one of these, and you'll have to come here and deal with it. Okay, so if you've been served, here's how it works. The person who's getting the order is called the petitioner. They are petitioning the court for an order of protection or restraining order, which means they are asking the court to order you to not have any contact. That means you have to stay away, no contact with them. You are the respondent. If you've been served, then you're the respondent, and you're the one who's going to be or might be ordered to stay away and not have contact with that person. And no contact means anything: in-person contact, electronic contact, email, instant message, text message, all that. You have to stay away. If you violate an order of protection, if you do have contact with them, you're going to get arrested. An order of protection by itself is not a criminal charge. It's a civil petition. It's a lawsuit, basically. But it has criminal consequences to it. If you violate it, then you can be arrested. You're now charged with a misdemeanor crime. Could get jail time on that. If you have an order of protection against you, you have to give up your guns. You have to get rid of your guns while that order is in place, and you can't buy a gun. Okay, so there's some real consequences, and it can, even though it's not a criminal charge or a conviction, it'll be there on your background. Okay, it'll be there for people to see. It's public record. It'll show that you've been subject to an order of protection. That doesn't look good, right? So what do you do? Well, you should get a lawyer. Talk to me, and you're going to have to go to court with your attorney and fight this thing. You can have a trial on it, a bench trial, a bench hearing, basically in front of the judge. Now, I mentioned the one who's asking for the order against you is the petitioner. All right. And usually these things, almost always, people involved in an order of protection, petitioner and respondent, they know each other, right? They're not strangers. Usually it's people in some kind of family or domestic situation. Usually it's boyfriend, girlfriend, or people who have dated or lived together or have a child together or were married. Sometimes it's family members, related by blood, siblings, rarely, but sometimes you see that. But it's usually people who know each other and have known each other intimately somehow. Okay. The petitioner, the one again who's asking for this thing, they've got to prove to the court. They got to prove by a preponderance of the evidence that there has been stalking, harassment, or abuse. Now, preponderance of the evidence is a low legal standard. It's the lowest standard we have in the law, but it is their burden. It doesn't mean, just because it's low, doesn't mean it's automatically easy. They got to put some proof forward. But it is a pretty low standard, and the burden is on them. So they can, it's going to just depend on the case, what they have. Sometimes they just come to court and it's just them telling the judge, their side of the story. Frequently in these kinds of cases, you do see some kind of proof, usually electronic proof in the form of text messages or emails. Okay, because if it's if it's stalking or harassment, I mean, you can stalk through text messages and those electronic kinds of communication. I mean, if somebody is sending just excessive text, like one after another, and especially if it's threatening language, I don't mean just insults. I mean actual threatening, like specific threats. I'm going to come to your house. I'm going to do this and that. I know what kind of car you drive. Like, that's serious. So, if they have that in the form of text message or other type of format, then they can bring that to the court and show the judge. They may have, there may be eyewitnesses. Maybe there was an incident at the home or somewhere, and somebody else witnessed it, and they can get that witness to court, and they can testify. So it just depends on the case. It depends on the case. Now, you as the respondent, of course, you can put on your own proof. You can testify for yourself and tell your side of the story. Sometimes that's necessary. You don't have to prove anything as the respondent. You have no burden, but a lot of times, strategically, it is best maybe for you to tell your side of the story, and maybe you have proof. Maybe you have an alibi. Maybe you weren't there when it happened, and you've got somebody to vouch for you. Okay, so it just depends on the case, and that's something we'll have to talk about. What kind of proof are we looking at? Is it electronic proof? Is it eyewitnesses? So the best thing to do is talk to me. If you've gotten one of these, that means sheriff deputies have come to your house and given you these papers. Then you've got a court date coming up. So talk to me and tell me what happened. I want to know about your relationship with this person, this petitioner. I want to know what they're saying, what allegations. The papers you get will have some of the allegations. I mean, it'll be a pretty brief, like, paragraph worth of whatever their allegations are, and you'll be able to tell me more about that, because this, again, you know this person. Now maybe they're lying. We'll have to see, but we need to look at the allegations, and are they credible, or are they just airing some grievances? But the goal is to get it thrown out, right? To get it dismissed, get it thrown out. We'll just have to see. So it starts with calling me and telling me about your case. I handle a lot of these cases in the Memphis area, and I want to help you out. Thanks for watching.